I know from the comments that some of you do hate it when I talk about where I am or what I'm doing at the moment or what room of the house I'm in. And I like doing that stuff because it's fun for me. It reminds you that I'm not just floating content in the internet wilds. I'm an actual human being and I get up to things. Um, so at the moment, I am not anywhere near my home. I'm in New Orleans. I'm in a hotel, and I am getting ready for an event that I'm doing tomorrow, or by the time you see this, most likely today. Today for you, tomorrow for me, just to make sure we get the time right here. And that event is going to be a discussion of Reconstruction Louisiana, where it's especially relevant. And because I'm going to be talking about Reconstruction, I've obviously been brushing up on just like key facts, dates, and that kind of thing. And that always gets me to reading about the law around this period. The law is a very important part of what's going on in Reconstruction, and it's a very important part of the story of how we get to the Civil War in the first place. Which, for example, had me reading a lot about the Fugitive Slave Act of 1850, and specifically the ways that Northern communities resisted the Fugitive Slave Act. And that has me thinking about something obviously occurring right now in the present, and that is the imposition of ICE on communities, of Customs and Border Protection on communities, and the way that they are mimicking the behavior of slave catchers. Although, as I have argued in a different video, perhaps not on this app, if you're watching it on YouTube and other places, although I think the fugitive slave catcher analogy works to sort of capture the relationship to these roving bands of ICE and customs officers to ordinary Americans, I think other analogies can be quite useful as well, especially analogies to European secret police, of which I'd say ICE also bears a similarity. So both analogies can work, both analogies are doing something there, they're doing different things, and as always, the point of an historical analogy is not to be correct in the sense that, oh, I have the best and most fitting analogy. The point of historical analogies is to illuminate something about the present and to better understand it. It's a bit of a digression. The point I want to make is that when you look at how localities and state legislatures responded to the federal imposition of power to try to capture fugitive slaves, the requiring of local and state officials to participate in these activities, which itself was a escalation from previous settled law in Prigg v. Pennsylvania. The Supreme Court had held that although states cannot nullify federal fugitive slave laws, they do not have to help federal officials or anyone carry them out. And the Fugitive Slave Act of 1850 more or less wiped that off the board and was a real giveaway to slave owners. The language that Northerners used was the language of states' rights. It was the federal government has no right to impose on us, the states, that we as states have these rights that you have to respect. And I know that we don't often think about states' rights in terms of opposition to slavery. Most often, the states' rights construct is about slave owners, about people claiming the right to protect the institution where it exists, and even to expand it. But if you look at the actual political and legal language of the 1850s and the 1840s as well, what you see is that the language of states' rights is actually claimed most often, most frequently, by opponents of slavery who hope not to see it extend into their states and hope to see it not extend into further territories. And the language of federal power, the idea that the national government is supreme over the state government, is really coming from slaveholders who are demanding that Congress do something to prevent free states from getting in the way of the institution. In a very literal sense, the Civil War was fought over states' rights, but not a state's right to have slavery, which really wasn't being contested even, but rather a state's right to be free from slavery. And what you see in all of this is the way that the Southern slave owners, the Southern reactionaries, they only gave lip service to notions of federalism and localism and the like. When push came to shove, they would use the hard hand of federal power against whomever stood in the way of their institution. And you can hear an echo of that exact thing in the present period. The imposition of ICE and Customs and Border Protection, in addition to being a human rights disaster, in addition to being an assault on the rights of Americans, is an assault on the rights of states in a real sense. Minnesota has in fact sued to end the operation, citing the 10th Amendment to the Constitution, which reserves to the states all powers not explicitly delineated to the federal government. And when you listen to what Trump administration officials are saying, they're not speaking the language of federalism, of small government, of respecting the decisions of local communities. They're speaking the language of federal power, of the imposition of force, of the states not as co-sovereigns, but as subordinates. All right, so big takeaways here. I think one of them is that very often the language of federalism and states' rights is not principled, but instrumental. It's just rhetoric used to achieve particular substantive ends. If federalism helps achieve that end, then great. People will embrace it. If not, then they will look for the things that will achieve that end. But having said that, that does not mean the federal system isn't useful. That doesn't mean that there isn't real power and authority lodged there. That doesn't mean that states' rights cannot be leveraged for the defense of substantive goods. Leveraging states' rights against slavery was the right thing to do. And in the present, as we think about rhetorical strategies when it comes to pushing against the president's use of immigration enforcement to pursue basically authoritarian ends, I think again it's worth looking at the language of states' rights and of federalism to make a case for what ought to happen, to make a case for the substantive end. It's a reminder that one should always use whatever tools, rhetorically, ideologically, practically, you have at hand to achieve your goal. Although always mindful of the upsides and downsides of whatever tool you're utilizing. Thanks as always for watching. If you like this, please consider this video and consider giving the page a subscribe. See you next time.